get your thought on the bill and why I'm assuming.
I think that would be great. Sure. Well, thank you for the record, Angela, our snow representative from Williston. Good morning.
Good morning.
I must say, your chairs in every way are superior.
They're pretty great.
We know this, but it's just sitting in it really pretty calm. So I have with me my floor report, which I do not intend to read, but I just highlighted a few key points. And I'll start by thanking the network and Charlie Parker and Listerman for helping me a lot, even with putting together the floor report. So before I repeat the words that Charlie helped write, I wanted to thank Charlie. So what H22 does primarily is improves really our civil protection order statutes to provide better relief to victims of domestic violence, sexual violence, and some. I know that you all know what protection orders are, but I'll just reiterate that they're a critical legal tool for victims. And that there are separate protection order statutes for victims of domestic violence and victims of sexual assault and stalking. So H22 impacts both statutes in different ways. First, it revises Vermont's civil stalking order to better capture device-related stalking. So there was concern, more I think experience really, that there was confusion in the courts regarding whether something like placing an AirTag in a bag or in a car or an electronic tracking device somewhere, whether or not that constituted course of conduct, which is required in the stalking statute. And so this bill 222 makes it very clear that that act is in fact with some dropping the tag and then surveilling in some way for 12 hours or more will constitute it. Second, it adds temporary possession of a vehicle to the form of available relief listed in the domestic violence relief from abuse order statute. And it does this in two different places. Because as you know, there's the emergency relief from abuse order and then the final relief from abuse order. So there are, in two different sections of the bill, you'll see section 3. Starting in section 2 is where we address the final relief from abuse orders and added possession of the vehicle as an option. And this is primarily for cases where use of the vehicle is necessary to reach safety, really. And I think you'll hear more about those cases from the network. And as I said, we put them separate. It's handled a little bit differently in emergency orders and final orders. And I'm just trying to be really brief here. So if I'm skipping over too much, I can add more detail. But the final thing that H222 does is add completion of a domestic violence accountability program to the forms of available relief listed in domestic violence relief from abuse order statute. And this suggestion came directly from the 2025 report offered by the Vermont Domestic Violence Fatality Review Commission. So you'll hear a lot more about these programs called DVAPs. Perhaps you're already familiar with them, but currently access to such programming is really only or primarily available through the criminal process. And we know that a lot of victims of domestic violence are not likely to pursue criminal proceedings for a number of reasons. And so the thinking is that by adding this to the relief from abuse order statute, perhaps more folks who are struggling with changing their behavior and learning how to be safe for the people they love and can have in their lives. More people learning how to change their behavior is certainly a good thing, and perhaps even a preventive measure for against future violence. And we really worked hard to make this work within the current structure of the statute and the court process. And I know Judge Dunne will talk more about this, but for that reason, we decided in-house judiciary to make it clear in statute that failure to complete such a program would not be a crime. So you'll hear more about that from other witnesses unless you'd like me to get into it.
Actually, I do just want to ask a question if, and again, kind of as you highlighted, this might be a question for someone else, but in the testimony that you got in the House, was there any conversation about if there was a parallel criminal case for whatever conduct is being raised in the civil part of this, how the requirement to go through DVAS, how would that play out if there's a parallel criminal case too?
Yes, we talked about that a lot. And these programs are confidential. And I'm trying to remember, I think you'll help me remember, we concluded that participants in the program are not going to be asked to violate their constitutional rights and implicate themselves in a crime. And certainly providers of these programs can give you examples of, what the program looks and sounds and feels like, what the process is like. But we were assured in testimony that it is at no point are participants asked to, it's not a sit down and say, I'm Angela and I did this. It's not about necessarily, naming your behaviors, specific behaviors, but more about learning healthy behaviors and safe behaviors.
That's good to know. I think the other piece of it is, so let's say somebody successfully completes the program and then a year later, they take a plea and part of it requires going through programming once again. Would they have to do that again, or would they be able to point to their previous successful completion and say, well, I already did it, so that part is checked off?
Oh, I don't think we addressed that specific scenario. I have a thought, but I'd rather someone who can answer definitively.
Sounds good.
Provide.
Any questions?
Is this the second time we've looked at this bill, or did we try to do the same thing somewhere else? Because I'm having a sense of deja vu.
We did a walkthrough of this bill
Okay.
prior. I think the representative wasn't available.
Okay.
First walkthrough that we did,
Yes.
and then it does
Okay.
feel like they've done work. Thanks.
I just wasn't sure if we had done this somewhere else, and that's why my brain was doing that, but thank you.
Any other questions, comments? Oh, okay. Great, thank you.
Thank you for taking the meeting.
Absolutely.
I do have a quick one. All right. What was the vote at the committee on this?
902.
Judge Sugg?
Good morning. Tom Zoni, Chief Superior Judge. With respects to, I'm looking at the as passed version, 222 10-page version. I would note that on page 1, it has the course of conduct is expanded to include surveillance, geolocation devices and such. That's the policy. It clearly identifies what the conduct is, and it makes it fall within that for the courts to be able to apply. On page 4, there is, and this comes back to the issue of the domestic violence accountability programs too. On page 4, on lines 20 and 21, it adds language that says, in order for parent-child contact under such conditions as are necessary to protect the child or the plaintiff or both from abuse, it adds in accordance with section 665A of this title. Section 665A is a specific section in our domestic statutes that relates to conditions that can be imposed for contact in domestic violence situations. One of those conditions is already that there is a provision that a court can order in a parentage or divorce case, for instance. The court can already order someone to participate under subsection B3 in a domestic violence accountability program. And so this brings those two together, if you will. It makes it clear in this statute, in the domestic violence statute for the relief from abuse orders, that we are referencing back to the other statute, and it puts them on the same footing. So it makes it very clear what courts can look at. On page 5, there's language, there's additional language that's been added about a vehicle. It's clear. This type of clarity, I would suggest, is helpful. Because oftentimes there are questions about, can you order a vehicle? Or one person would say, well, it doesn't say you can. And it gives some guidance for courts on the criteria to be able to do that. And then we get to the domestic violence accountability program language that has been added. If you look at the statutes for relief from abuse, most of the provisions of a relief from abuse order, not all, say that do not do this, do not do that, do not go here. And so the majority of the provisions are prohibited. This type of provision is one that has an affirmative obligation on behalf of the defendant. And that affirmative obligation that the court would be ordering is them to participate in a domestic violence accountability program. It is not in every case. The court would have to assess whether in a specific case it's appropriate. The structure that the House passed is one that recognizes that this type of program is something that can be beneficial not only to the instant parties, but also for the future. If someone gets the assistance that they need, they may be able to conform their behavior in the future and be safer for other partners. And so when we look at this, it's two prongs. One is if you don't successfully complete it and you're ordered to, that can be used to extend the order. That can be a factor the judge considers. On the other side, the incentive for the defendant is that if you do the program, you can come back in and say, I've done the program and maybe shorten the order or amend the order. And so there's a benefit for both, for the order to be followed, and there's a consequence if it's not. There's also the ability for civil contempt. Senator Isham asked about, well, what happens if there's a relief from abuse proceeding and someone successfully completes the program, and a year or so later, there's a criminal charge and they're convicted and they need to do the program. My experience is generally that they would do an assessment in the criminal case. And if the assessment came out that they have already completed the program, they don't need to do it, that they wouldn't necessarily have to do it all over again. I can't think of times where someone has engaged in substance abuse treatment, worked hard, done well, and then because that happened voluntarily, if you will, before they got to the sentence for the crime, that they had to do it all over again. Generally, there would be an assessment to determine whether or not there's further treatment or programming necessary. And that's about it.
Maybe what?
Yes, thanks for being here, Your Honor. This is related to civil stalking orders.
Civil relief from abuse orders.
Okay. Are these available 7 days a week?
24 hours a day. Yes.
Or I want to do. Thank you.
The Title 15 protections. Anytime you see the Title 15 orders for relief from abuse, they are 24/7, 365. And with the governor signing S21 as of September 1st, or not S21, with the governor S9, with the governor signing S9 as of September 1st, in the Title 12 stalking and sexual assault statutes, the sexual assault orders will be available 24/7.
So why is it stalking?
Because the majority of stalking cases we see are matters that are quite different than situations where you have the immediate need. Oftentimes, the majority of them, frankly, are neighbor against neighbor. Other matters that would be course of conduct and such that could be handled through law enforcement if necessary during after hours.
Thank you.
Any proposed changes that you think are necessary for this, fixes or anything that, you know, that's
The
clear?
language went through some review in the House, and I think it is, it's language that, as I understand it, advances the policy that the committee in the House felt was appropriate after listening to the testimony, and it's language that I think the courts can apply. I would also note that one of the things we tried to do in the judiciary is, we got ahead of this one a little bit. Because if there's a bill that passes that we think there might be a benefit to judicial training on, we try to schedule a training as part of our judicial college. And so at judicial college, we actually have a session being presented by by 3 of the domestic violence accountability program members from across the state to the judges on what the programs look like, the criteria for admission, how things would work, so that if this passes the Senate and is signed into law, we actually have the training done to enable the judges to have a better understanding of the programming that's out there to utilize what this new tool that the legislature has given us.
And that's in June.
That's in June.
It would take effect July.
I believe this was July 1st.
Great, okay. Will you please see if the state attorneys and defenders want to chime in on this? Thank you. Okay. Okay, committee, any questions, comments? Thank you for your great day.
I can run up to the House floor. I'd love to stay, but if there's anything I can help with.
Thank you. Yeah, thank you for coming down.
Thank you, George.
We will just wait to hear from prosecutors and defenders to see if they have any significant input they want to provide. If not, we'll take it up for a vote sometime this week. Probably tomorrow, you know. 44. Yes. That'd be honest.
Another draft. I'll work out.
Who wants to do Same.
Yeah, no changes from the one we looked at a few weeks ago.
Before we start any discussion, committee, are there any questions, comments, or concerns? Anything that we want to clarify before we consider voting?
Where'd we land? Hope I'm thinking on the right book. Where'd we land on the section with the violation? Did we land on just the one? Is that this bill?
No, that's 105.
All right, never
That's
mind.
tomorrow.
Sorry.
Yeah, are you talking about the cannabis?
Yeah.
Yeah,
Sorry.
with this one, I think the main work that we did was differentiating when it comes to hindering search warrant.
Go.
The criminal refusal,
Yeah,
basically,
yeah.
where there's, in one part of the statute, there's the expectation that you submit to the search warrant, and then the criminal refusal is that elevated mental state of knowingly hindering
No. Yeah.
the execution.
See there.
Oh, for the record, then for us.
And aside from that, I don't think we made any other major changes.
No, the only other one was the one suggested by Department of Motor Vehicles, and that's right on page 1, subdivision 8 there. We're striking out the language on 18 through 9 through 20, and then adding the language on 17 and then 20 through 20 on the page 2, just to make it compliant with those anti-masking statutes. And also there is another bill that affects similar provision of House Transportation and Jamie Leonard and I coordinated to ensure that the language is the same to reflect the changes that they're making in that bill as well.
Any questions on that?
No, I don't know the right bill.
This is, I mean, I still have concerns about the difference between buildings and bodies. I think incursion into a building is different than incursion into someone's body. And I also have a note in my first draft that there are constitutional concerns around this. I don't know why I have that note, but could you remind me why I might have that note? No? Okay.
You know, to obtain a blood sample, you need to, it's all contingent on a search warrant. So they will have already, need to have been vetted through a mutual magistrate. You know, I think maybe the concerns that were raised by the Defender General were, you know, what occurs in that situation where I think that the committee had a lot of discussion where someone is unable to comply, what that means and how is that interaction, because the search warrant is really an obligation on the law enforcement officer to execute it according to the parameters of the document, not so much a command on the subject of the search warrant. And so I think those were some of the concerns that the Defender General raised, is that changing the language so it wasn't as sort of consent based.
Okay.
So that's one of some of the
That's what we
changes
did.
that were made here to
Yeah,
edge against that issue.
Okay,
yeah,
that's helpful resetting.
Yeah.
Thank you.
yeah, just to add to that, I think it had to do with the idea of implied consent
Yes.
for a blood draw versus a breath sample, because as you mentioned, drawing blood is far more invasive than blowing air out.
Mhm.
And so there can't be, as best as I can remember, there can't be implied consent for a blood draw, but there can't be implied consent for breath.
Right.
And so we can't create that penalty for implied consent for blood draw because there can't be implied consent. So we're making it so that if you're knowingly
Okay. Yep.
hindering the execution of a search warrant, then you can be held liable for that. Is that?
Yeah, that's a good summation. And then also what that does is keep, you know, any sort of the basis for criminal refusal in that context, it keeps it within that sort of DUI realm without elevating it to a felony that carries more prison sentence and doesn't have the rehabilitative aspect of the DUI laws.
And that's what would happen now in
Correct.
these instances.
Yeah,
Okay.
because right now, really the only avenue for law enforcement to enforce it would be an obstruction of justice charge, and that's a felony.
Does that happen? Is there any data on that actually happening in an instance like this where obstruction of justice is charged?
I'm not sure if there's like broad based data. I think there's maybe been some anecdotal testimony to that effect, but I can't speak to that definitively.
Great. Thanks.
Any further questions, comments? Thank you, real quick. And so we're voting, we have 1.1 in front of us.
2.1.
2.1. All right. So if there's no further questions or concerns, I'd entertain a motion to vote version 2.1 out favorably. So any further discussion? Great. Senator Maddox.
Sure. Senator Norris,
Yes.
Senator Vihoski,
Yes.
Senator Baruth,
Yes.
Senator Matos, yes, Senator Hashim,
Yes.
5-0-0.
Is there anybody with a burning desire to report this bill out?
It's got ex-sheriff for.
Oh, geez. I'll report it. Ah, thank you. Senator Forrest. Great. So we can go up until 11, slight change in schedule for having that council would come in. Let's talk about a bill that is economic development. That pertains to immigration status and housing. Your chair asked us. Let's take a look at it real quick. Before they report anything.
What time they come in? I can leave 11.
Oh,
Change. I got a swearing ceremony for our assistant judge today.